can take
Okay.
it up. That's
Yes.
2025 matter. I think the paper book is also ready.
Yes, it's small matter, my lord.
Okay. Okay,
Okay,
come
I
over.
can come. Okay.
Daily list for motion item number 1.
What are these petitions? All the four are analogous.
Not analogous, Your Lordship. It's
Acha.
a different case.
Different.
Different case.
Okay.
But we file it together in a one day. On the same day, we file it.
Oh, so the numbers are
Yes.
chronological.
Number are 18, 19, 20, 21.
Acha, so what is this petition about?
Lordship, this is the NDNPS case, and the respondent was granted a bail by the learned special NDNPS court.
You have come for cancellation?
Yes, Lordship.
Oh, acha. So, okay, let notice go today.
Lordship, notice
This
may
has
be
come up
issued.
for the first time.
First time, Your Lordship, yes.
Acha.
In all 4 cases.
Sir, so notice has to go.
Lordship, yes.
Okay, heard Mr. Johnny Tachwa, learned counsel for the petitioner. There's no one from the state side. Acha,
Lordship,
you are for
I'm-
Union of India?
Yes, Union of
Okay,
India.
okay.
I'm special
This
PP.
is an application filed under section 528, read with section 483 3, within bracket 3 of BNSS 2023, for setting aside the impugned bail order dated 12/12/2025, passed by the learned special court, NDPS Act, Aizawl Judicial District, Aizawl, Mizoram, in bail application number 524 of 2025. Full stop. By the said order dated 12/12/2025, the learned court had granted bail to the sole respondent in connection with DRI S/C number 01/CL, all capital letters, /IMP /NDPS -METH /DRI AZL /2025-26. Acha, why have you cancelled? Why have you prayed for cancellation? Any subsequent event or bail granted without taking into account the merits?
Yes,
What?
Lordship, without taking any matter. Because the bail was granted on the ground that the arrest intimation was not given to the family members. But we have given that to the family members of the accused.
Signatures were there.
Signature was their signature in the sense that we have informed through telephone, because they're from, the accused wife is from outside Mizoram. It's from Tripura.
No, but arrest memo, you're talking of section 36.
Not arrest, yes, intimation of the arrest, grounds of arrest,
Are you talking of 36 or 48?
48, Your Lordship.
48.
48.
So 48, the procedure is not to give the information through telephone.
Yeah, Lordship.
If he stays outside the district or the state, you have to send the information to the concerned police station. Police station will serve
Lordship,
the notice in writing
In writing.
to the relative.
Lordship, yes.
So if that is not done, then bail is properly granted. That cannot be a ground for cancellation.
Lordship, that is one of the ground, and another ground is that it says that the full details of the grounds of arrest was not properly explained to the accused, but we have done.
But yes, details sometimes is required at par with Prabir Purkasta case.
Lordship, yes.
Simply saying that you are arrested in connection with this offense and you have the right to apply for bail, those will not be the full details.
Yes,
You
also.
require to give more than that.
Lordship. As the-
Anyways, we will examine,
Lordship, yes.
but I don't think so. These are proper grounds for cancellation. Okay, you're right. The learned counsel for the petitioner states that bail was granted on violation of provisions provided under section 48 of the BNSS,
Lordship, yes.
but he submits that the necessary intimation was given to the family member of the accused person as required under the said provision. And what else you said? What is the other ground?
And Lordship, the
Oh, details.
Details
He,
we have
the
for this.
learned counsel further submits that bail was also granted on the second ground, that full details of the offense was not intimated to the accused person as required to be given in the grounds of arrest under section 47 of the BNSS.
Lordship, yes.
The learned counsel, however, submits that details regarding the offense was in fact given to the accused person. As such, on these grounds, the learned counsel submits that he has challenged the bail order, bail allowed to the respondent. Full stop. Issue notice, returnable by 3 weeks. Petitioner to take steps for service of notice upon the sole respondent by speed post or by usual process. List this matter. Do you want records?
Maybe
Records will be required, I think,
yes, maybe.
if you are going into the merits of the case.
Yes, it may be required, Lordship.
And so, you will bring the what? Charge sheeted
Charge sheet, yes, already charge sheeted.
or charge sheeted?
I'll bring the charge sheet next.
A trial is on.
The trial is about to begin, Your Lordship.
Acha. Acha, let the accused appear, then we will think
Yes,
of
yes, yes.
calling the.
That will be-
Release this matter on 13th of, no, 17th of August.
Lordship,
Okay?
yes.
Release this matter on 17th of August 2026. Rest matters are also for cancellation.
Yes,
Those are different accused of different FIRs,
the different files, Lordship, yes.
different FIRs,
Yes, yes.
different cases.
Different cases.
So,
But the
same-
grounds are more or less the same because the learned trial court had granted bail almost the same grounds, Lordship.
okay, on 47, 48, violation.
47, 48 violation.
Yes. There are so many bail orders yesterday also have passed.
Yes, yes.
You will challenge it again. No. Okay, arrest, the orders will
Same,
will be
yeah.
the same.
Then name of the accused and address are different. Also.
These are only in the cost title. I have
Yes,
not
yes.
recorded the name of the accused here. So, okay. So, there are only sole accused persons, right?
Yes, solo accused person.
Same order will follow in 2, 3,
Yes,
4.
yes, also.
Okay, same order. Okay.
For admission, item number 5.
Yes, MAC appeal.
May it please your lordship, lordship, in this mega appeal, we are supposed to serve notice by way of dusty to the respondent number 2.
Acha.
However, lordship, we are still unable to locate the exact location of the respondent number 2. So, lordship may kindly grant another 2 weeks to find the exact location of the respondent number 2.
Acha.
to
So,
complete
you
the
have not
service.
been able to serve notice upon?
Respondent number 2.
Respondent 1 is served.
Yes.
Respondent number 1 you are appearing.
Yes, my lord.
You are the department, right? Insurance company.
Yes, lordship.
So you need some more time to serve, learn for further to serve notice by dusty mode. You were given, opportunity to serve it by dusty mode. What happened?
Yes, we are given.
Correct address was not there.
Yes.
So you have already taken. Let's see what is the result to that. What happened?
We have a tip that he's staying in Champhai district, so it's a bit far from Aizol. So
Acha.
we are still unable.
Okay.
We are still under investigation to find out the exact location.
No, on the last occasion you had said that the address was not found, was not correct. So you have not tried to find out and thereafter take the dusty service.
Yes, we are trying to find out.
Ah.
Yes, and we have already a tip that he's staying in Champhai district.
So you will have to take this justice service again.
Yes, lordship.
Okay. Heard, Mr.
Vanal Tranpuya. 40.
So and so learned counsel for the appellant and Mr.
Samuel Alompuya.
Learned counsel for respondent number 1. The learned counsel for the appellant submits that he could not effect the service of notice upon respondent number 2 by dusty mode, since the correct address, since he could not take out the correct address. However, upon investigation, he found out that the respondent number 2 is staying elsewhere, and as such prays that he may be again allowed to take service of notice upon, to take steps for service of notice upon respondent number 2 by dusty mode in the newly found address. Pray is allowed. List this matter after 2 weeks
Deeply obliged.
on a date to be fixed by the registrar.
Item number 6.
If I may, Your Lordship. Service upon the respondent number 3 was sent by speed post on 16/6. However, the same was returned unserved as the address was incomplete.
Notice to respondent number 3 has returned unserved. Okay.
Yes, Your Lordship.
So you will again take fresh steps?
Yes, my lord. We are yet to ask for the complete address. So by the next court date,
You have the complete address now?
Your Lordship, we are yet to ask for the address.
Take
So
out
by
the- What about respondent number 1 and 2?
it's already been served, Your Lordship.
Acha, they are not appearing.
I don't.
These are what? Drivers? What?
No, the respondent
Owner.
number 1 and 2 are the claimant in the MSCT. So by the next court date, I think we will
Yes, one
able
second.
to submit the complete address. So if Your Lordship may kindly be allow some time.
But nothing is reflected as far as 1 and 2 are concerned. What happened? 3 is okay. Has 1 and 2 is also not served.
That is the only instruction that my senior has given me, Your Lordship.
But 1 and 2 are also not served. 3, there is something which has come back, that incomplete address. But you take fresh steps in respect of all the 3 respondents.
Yes, Your Lordship.
Okay?
Okay.
Because the notice is issued to respondents by speed post on 18/6.
Yes, Your Lordship.
Duly signed AD card is received from PA, Post Office, MSCT, Aizon, in reference letter issued calling for TCR. That is different. Scan copy of TCR has been received. But as far as 1 and 2, no. Right. Okay. Miss,
Anila and Koli.
Learned Counsel for the appellant submits that as far as service of notice upon respondent number 3 is concerned, the same has returned unserved with the postal note that address is found to be incomplete. As such, she submits that she be allowed to take fresh steps upon finding out the complete address of the respondent number 3. It is also seen that service of notice is not complete upon respondent number 1 and 2 as well, and that the steps were taken on 17/6/2026. As such, the appellant is directed to take fresh steps upon all the respondents, including respondent number 3. List this matter again on 28th of August,
Deeply obliged.
2026. What about this I? I is for what? Oh, this is to serve copies
Yes, Your Lordship.
for staying the operation. Okay, let the service be over.
Deeply obliged.
Item number 7.
So, New India Assurance, the same counsel can appear. She left. Yes, you can appear. Yes, Lal Fakoma, you're there. New Assurance.
This one is connected to the previous case.
Acha, same.
Same. Everything
Wait,
is the
the
same.
respond numbers, incomplete address again.
Again, everything.
Same matter.
Same matter, different claimant. That's all.
Still different claimants. So here also I see
Same thing,
respondent
my lord.
number 3
We
is
will
not
take
served.
fresh steps, my lord.
Okay. And what about 1 and 2? Same.
Same, my lord. Because everything went together.
Acha.
We'll do the needful, your lordship. We'll take fresh steps.
AD card for the same order will do. Amit, tell Amit to type out the same order. Yes, yes, Mr. Papa.
Item number 8.
Number 8. Yeah, are you paying for 8? Yes. This is writ petition. Why it has come up?
Lordship, in this matter, notice is complete. Service of notice is complete in this.
Complete,
Yes, Your Lordship.
but no representation.
Yes, Your Lordship. So I pray this matter may be listed on 4th August, Your Lordship, for further proceedings.
Respond number 1 to 4 and AD cards for 2 to 4 with their signatures have
Yes.
been received.
And also, Your Lordship, from the respondent number, for the respondent number 1, I was also informed that they received the notice.
Acha. In the correspondent file, page number respond. Okay, heard Mr.
Lalthang Moya.
Long-term lawyer, learned counsel for the petitioners. Petitioners. There are 263 petitioners.
Yes, Your Lordship.
Petitioners. It is seen from the office note that service of notice upon respondent number 2 and 2 to 4 is complete as AD card has been received back. However, in respect of respondent number 1, there is a note saying that service report is not yet complete, but the learned counsel for the petitioner submits that he has information that service upon respondent number 1 has also been completed. Benisham, you are paying for somebody? No. Achha. List as such. However, there are no representation on behalf of the said respondents when the matter is called up today. List this matter again for further consideration on 12th of August,
My Lord, 4th.
4th of August.
Yes,
4th of August 2026.
Item number 9.
Yes, Mr.
When the judge, as per the office noting, service on respondent number 1 is complete. Respondent number 2 AD card has not been received back. Your Lordship may kindly give us some time to verify the address of the respondent number 2
2.
and to take fresh steps.
Achha.
Because in the trial court, the respondent number 2, being the defendant number 2, had submitted the written statement and contested the suit. So we can try to find out the address from her lawyer.
Okay. Heard Mr. A.R. Malhotra, learned counsel for the appellant, and Miss
Miss Rosie for the respondent number 3.
Achha, for respondent number 3. How many respondents are there in total?
3.
3.
As per office noting, 1 is complete. Service.
Yes. Postal receipt of service on 1 has been received from the post office. No, 2 is also complete. Postal receipt for service of notice upon 1 and 2 has been received.
No, that is only the receipt, Your Lordship, the AD
Acha,
card.
acha.
AD card.
Oh,
Acknowledgement card.
Reference, the matter is laid down before the ID card has received only for 1.
Yes. Acknowledgement due card.
It is noticed in the office note dated 15/7/2026 that AD card with respect to service of notice upon respondent number 1 has returned. However, in respect of respondent number 2, it has not yet returned till date. Mr. Malhotra, learned counsel for the appellant, submits that he be given the opportunity, he will be given the liberty to take fresh steps for service of notice upon respondent number 2 after he finds out the correct address of the said respondent. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
I'm open.
Item number 10.
Yes.
My lord, I have received a copy of the written objection filed by the respondent.
What is this IA for?
This is for condemnation of 941 days delay, my lord.
941 days.
41
You are
days.
appearing for the respondent.
Yes, yes, Lordship.
You have serious objection to this?
We have already filed.
Or you have filed your objection?
Yes, yes, Lordship.
Okay, now I can hear this IA.
Yes, that can be done, my lord.
Okay.
For the time being, Lordship, the leading counsel is on maternity leave.
And this is only condonation. Let me see your objection and pass orders.
Since I'm not well acquainted with the case, so I'm just
Okay, who is the leading counsel?
Emily L. Changte.
Your names are not reflected in the cause list.
Yes, Lordship, we have already filed our vaka.
Okay. So not today.
Yes, Lordship. If this matter may kindly be taken up after maybe 4 weeks, since she's on maternity leave.
Okay.
My lord, if I may make one more small submission, we have been evicted from the suit land by the respondent, by the sole respondent. And
You are
that-
evicted from the suit list.
Yes, and that we have been threatened that the property, the residential building within the suit land will be demolished. We have been threatened time and again by the respondent. So, my lord,
Acha.
if that much time is
Respondent claims title over their property.
given, yes, if that much time is given, my lord, then maybe a status quo may be maintained, my lord. That may be reflected. Otherwise, my lord, we have been.
No, first of all, your delay has to be condoned.
Yes.
Now, how can I pass status quo
then,
in
my
your...
lord, then, my lord, if this item may kindly be taken up next week, my lord.
According whatever he
Since-
says, subject to his convenience, what happened?
Yes,
Next week
Lordship,
it can be
Lordship,
done.
Next week, I don't think she can come here. Since her child is only about 2 weeks old. So,
My lord, my learned friend had also signed on the Bakalat Nama, I believe. His name is.
Yes, he can do
Take
it.
up the matter.
And our objection is not on record. Your objection
we
is...
have already filed on day before
Oh,
yesterday.
yes. Old cause title. No, your objection is not on record. Right.
We have already filed on 15th of July.
15th of July.
Yes, Lordship.
But it's not on record. In the IA you have filed, yes.
Yes, Lordship. In the IA.
Objection.
Yeah.
Okay, but then it's not on there. What is this? Okay. An objection is not yet filed. So you, okay, you have filed, right?
Yes, Lordship.
So let the registry put the objection on record on the next date.
Yes, Lordship.
So, okay, heard Mr.
Tila Zakima, my lord.
T. Lal Zakima, learned counsel for the applicant, and Mr.
El Lanunciama.
L. Longshamba, learned counsel for the sole respondent. The learned counsel for the respondent submits that the objection to the condonation application has been filed, but the same has not been found in the records. That although Mr. So-and-so, the learned counsel submits that the objection has been filed, but the same is not found in the records. As such, the learned counsel is given the liberty to check with the registry and the registry is thereafter directed to put the same in the records. List this matter. Without the objection, I cannot take up. So list this matter on next week.
2 weeks.
List this
Maybe
matter.
after, Lordship, maybe after 2 weeks.
List this matter on 3rd of August,
Okay.
2026.
Okay. Obliged.
Understood. Now that the file is not here, I cannot take up. Afternoon. Okay, at 2. Huh. Okay. Yes, Mr. Lal Pakama, the matter has not come. So, we will proceed to the hearing list now.
My lord.
Okay.
Hearing list, item 8.
Item 8. Yes, who is appearing for item 8? That's a criminal appeal, Lalrem Sangha. Okay, call some other matter. Yes, Miss Veneshami, any matter is ready? Item 10. This is your appeal.
Item number 10.
But what about the other side? Who are these counsels? Have you seen them today?
No, Your Lordship.
This is appeal against acquittal under what provision?
Item 11. No?
Item 10.
Item 10. Your Lordship, this is appeal filed by Miss Linda.
This is state appeal against
Yes.
acquittal under what section too, we don't know. This is, which is state appeal? This is the one. Yes, Miss Counsel? Instead of telling her, you can tell it to me. Yes, instead of telling her, you can tell it to me. What is the matter?
I'm sorry, my lord. Well, this is a state appeal. It's taken up by Miss Linda, and we're taking the consent of the other party that both the council will not be unable to take today. So if
Today
the
they are
matter
not
not able, my lord.
Item number 10. Where is Miss Linda?
She's dealing her personal matter.
Acha, acha. Okay. So, but the other counsels are also not there, but then consent was taken or
Yes,
something?
yes, my lord.
Okay. As prayed for by the learned counsels for all the parties. List this matter. This is 22 matter. Number of years have
Yes,
gone.
my lord.
List this matter after 2 weeks on a date to be fixed by the registry.
Yes, my lord. And also, my lord, item number 28. It's also the same council. Mr.
Item
Chair.
28.
Yes. Part 2.
Part 2.
Yes.
This is not a state appeal, but by this one. You are for,
I'm for
On behalf of Miss Linda.
on behalf of Ms.
But the same council with Mr. Jesse.
Acha, they are on the Lalsnu Sunga. Okay. In item 28 also you write? As same. As prayed for by the learned counsels for all the parties, list this matter after 2 weeks. So 10 gone, 28 also gone. What about 8? The learned counsels are not here.
It's also taken up by Miss Linda, my lord.
Your Lordship, item number 7, 8, 9, 10, and 11. And also item 14. 14, 21. Those are taken up by Miss Linda. Those
By
cases
Miss
were
Linda.
taken up by Miss Linda. Yes.
And what about 16? These are Gauhati advocates. 16?
Yes.
Anybody appearing? Already passed. Okay. So what is left?
Item 19, Your Lordship.
19. Yes, 19. Anybody appearing?
Here I'm appearing
Yeah,
on
you are
behalf
there.
of state.
Item number 19.
What about the
19.
19 years?
19.
19. Mustaqur Rahman.
Yes.
But what about the advocates for the appellant?
I have no idea, Your Lordship. They keep on absent for, I believe, that 3 consecutive times.
They want to do.
I don't know. It seems that they have changed their counsel.
Oh,
But the new council, I haven't met, not even once they have come up here.
acha, acha.
So if this matter may be listed as a fixed item, Your Lordship, because it is
Acha,
pending
just see the
for
orders.
quite long
List
time.
this matter after a week. List this matter. So many adjournments.
Yes.
None appears when the matter is called. Rupesh Datta was there. Yes, you are appearing for somebody.
No, my lord, in item number 27, that matter will be fixed today, my lord.
27.
Yes,
27, you'll do it.
I can do it, my lord.
Oh, yes, you were there online. You were there online, right, in the morning?
Yeah.
Okay, we will take up 27. We will see it together, don't worry. Okay.
It's small matter like reduction of sentence only, my lord.
Uh-huh. So, okay. Yes, Miss Venetia, you are
my-
seasoned lawyer now, you can do it.
The problem is that I didn't even have the file.
You can
because-
take the
All right.
records of this
All
case. Normally, when I was that side and I was a PP, I used to take the records and do it.
All right.
He is there to assist us.
It's okay, Your Lordship. And regarding item number 19, Your Lordship, if you can have a fixed date.
Okay. But on one occasion, Mr. Rupesh Datta appeared, but after that, he is no longer appearing. Okay, we will just pass it over then. None appears for the, and 19 not likhiba. None appears for the appellant on call. However, Miss Venetia is present for the state of Mizoram. List this matter further on when do you want?
27 August.
27th of August, 2026. Okay. Or shall I write that these set of councils are no longer there?
Yes. If
Are you sure about the
Yes.
information?
Sure.
Eta likhe diya, miss. But then what to do? No new set of councils have not come. Then in that case, amicus curiae has to be appointed. Appeal cannot be dismissed for non-prosecution and all.
I understand. Your Lordship, if possible, if on this fixed date, if they still didn't appear, so the amicus can be appointed.
Okay.
in that-
It is stated at the bar that the learned counsels whose names appear in the cause list representing the appellant no longer appears for the said appellant. And on the next date fixed, if the said appellant again goes unrepresented, an amicus curiae may be appointed for the ends of justice. List this matter on screens.
Item number 27.
Oh, that was taken by the PP. It's okay from records, she can do it. Yes, Mr.
My lord,
Counsel.
this is a jail appeal. This is regarding
NDPS again.
NDPS matter. In this matter, there were two accused. The appellant is the accused number 1, and accused number 2 is Zaudin Puya.
Acha, there are two appellants.
No, only one appellant, and 2 accused in the trial court, my lord.
Two accused in the trial court, both of them were convicted.
Yes, both of them were convicted in the CC stage, my lord, charge consideration stage, since they had voluntarily pleaded their guilt.
Acha.
Yes.
One of the accused person had admitted the guilt.
No, 2 of them admitted their guilt.
Oh, both of them admitted.
Yes,
Then trial went on.
Not trial. Sentence hearing was conducted immediately.
Okay. At least the trial should have been undertaken. Even if they pleaded guilty. That is what the Supreme Court said.
It was not done in this case, my lord. That's why.
Yes, Mr. Venetia, there are judgments where it is said that even if they plead guilty, but
Yes.
for the ends of justice, trial should be
That
conducted.
has to be conducted.
Here it is not conducted.
Yes. So in that case, Your Lordship, if it is sent back to the lower court,
My lord, the period of sentence is almost over.
Oh, the sentence
Yeah.
is also over.
I'll just
Okay.
give you some facts, my lord.
Ah,
In this connection, there was a seizure of 15 grams of heroin, my lord.
where is the FIR?
FIR,
FIR not there.
yeah. FIR is in phase 1, my lord. No, report of seizure, my lord, that is. It's
The
not
report
here.
of seizure, okay.
My lord, to make it short, I'll just cut something, okay? There was a conviction order dated 19/5/2025, which is in page 9, my lord. And the operative person is in page 12, my lord. And based on their voluntary plea of guilt, my lord, sentence hearing was conducted against the two accused, my lord. The accused number 1, who is the appellant, was sentenced to undergo RI for 8 months and in default and fine of 2.5 lakhs, my lord. 8 months and 2.5 lakhs, my lord.
Acha, they are convicted under 21B.
21B, yes, my lord.
Convicts are remanded back to judicial for sentence hearing. Then where is the sentence hearing?
Sentence
Next
is in
week.
page 13, my lord.
Okay.
21st of May 2025, my lord. And in page 14, my lord, para number 7,
Yes, para number 7.
yes, my lord. Here, the appellant was convicted,
Acha.
sentenced to undergo RI for 8 months and fine of 2.5 lakhs, my lord. And in default, to undergo for another 1 year, my lord.
What about the other accused?
Other
Zodin
accused is
Piwa.
RI for 5 months, my lord, and
Acha.
fine of 10,000, in default 30 days, my lord.
So his incarceration period is over.
For the
Yes,
for the
undergone.
appellant, the normal incarceration period is over in
He was not on bail and all.
not on bail, my lord. He now he is in custody for 1 year, 4 months, and 21 days.
So he has overstayed.
No, my lord. In his fine, there was a default clause. In the fine imposed against him, there was a default clause.
So default clause was RI for 1
RI
year.
for 1 year. If we calculate RI for 1 year, it's going to be finished on 27th of October this year, my lord.
27.
Yes.
So still he is okay.
Yes.
And the other accused is released.
I think he's already completed his sentence. Yes.
He's completed his sentence and
Yes. Yes.
he is out of the jail.
The reason for awarding a higher punishment of this appellant is because he was
Whether
convicted.
this in default of fine, the RI for 1 year is proper.
Yes. ma'am.
Main substantive sentence is 8 months.
Yes.
And then default clause it is 1 year.
Yes, ma'am.
See the provision of CRPC, I remember that was what? 31 or something? Give me CRPC, not BNSS. CRPC, yes. Before that, huh? See, the default clause cannot increase half of the sentence, I think. Just
Yes,
see
my lord.
section, what is that provision? You remember?
I'm not exactly remember. Madam.
This was, I think his sentencing was wrong. Where was it? Section 31 or something, sentences, right? And then, no, 31 is different, 32. Oh yes, 30. Read 30, section 30 of CRPC. The court of a magistrate may award such term of imprisonment in default of fine.
The court of a magistrate may award such term of imprisonment in default of payment of fines as is authorized by law, provided that the term is not in excess of the powers of the magistrate under section 29.
No, that is not the case.
Shall not where imprisonment has been awarded as part of the substantive sentence exceed 1/4 of the term of imprisonment.
So shall not. So the
Yes.
term means the term of imprisonment in default of fine. So the term shall not, where imprisonment has been awarded as part of the substantive sentence, exceed 1/4 of the term of imprisonment which the magistrate is competent to inflict as punishment for the offence, otherwise than as imprisonment in default of payment of fine.
Imprisonment awarded under this section may be in addition to
My lord, if we look at section 65 IPC,
65.
yes, there is a provision limit to imprisonment for non-payment of fine when imprisonment and fine awardable.
65. 65 of IPC?
Yes. I don't know whether it is can be used in this case.
the term for which the court directs the offender to be imprisonment in default of payment of a fine shall not exceed.
I think it's
Yes.
similar with the CRPC.
This is similar.
1/4 again, my lord.
Shall not exceed 1/4. 1/4 of the term of imprisonment, which is the maximum. But however, Your Lordship, here it is the maximum. So the maximum punishment is 10 years, I guess. In
21B.
yes.
Not less than.
Not less than maximum 1/4 or maximum 1/4. Yeah. A maximum. I have which is the maximum fixed for the examining one.
But okay, whatever.
My lord, he was arrested on 27 to 2025. 27 February.
27th of February.
Yes, 2025. And if we counted from that date, the period for 8 months will be 27/10/2025. That is the sentence.
So he was never on bail.
Never on bail, my lord.
Acha, he pleaded guilty during the
In
charge framing.
Charge framing, yes.
That is 28. What is the section there?
Charge framing
228.
is in 19/5, 2025.
19.5.
That is the conviction order, my lord.
Okay. That is the conviction order. But from the day of arrest, he is inside.
Yes, my lord.
Just see the order sheet, Miss Venishami. If he is inside since 27/2. So his 8 months will be 27/10.
10, yes, 27/10/2025, the 8 months period will over. And
The default
the default
will be 27/11.
27. No, my lord, he was awarded in default 1 year.
1 year.
Yes.
So from the date, another period of 1 year.
Another period
So
of 1
from
year.
the date of his conclusion of the substantive sentence.
Yes.
So it will conclude on 27/11.
27/10.
Huh?
27/10.
26.
Yes, yes.
27/10/26.
Yes.
27th of October 26th.
Yes, my lord.
He will be completing his full sentence.
Yes. And
So
now,
there is still some more months to go.
he has undergone 1 year, 4 months, and 21 days.
Yes.
Till today, 1 year, 4 months, and 21 days. If we exclude the 8 months period, it's already 8 months, 21 days. 8 months, 21 days. And he still have 3 months and 9 days.
So, okay, on what do you say on the merits of the case?
Marriage, since he voluntarily pleaded guilty, I cannot press on the merit, my lord.
But you have the judgment saying that even if he pleads guilty, the trial court should conduct the trial. Do you have judgments on that?
And right now, I didn't bring any adjustment, my lord.
So, what are your arguments today?
To show leniency, my lord, and to make it lesser the sentence, reduce the sentence period, my lord.
Or you want to reduce the sentence and
Till 9 months, my lord, if the court can show leniency in this regard, my lord.
and he will be given some remission also. He will be getting that benefit of remission. So, have you calculated the remission period? He can be out by now.
Yes. Now he has already undergone again 8 months, 21 days, from calculated from 27th of
So
October.
till date, how many months you say? What is the incarceration period? 1 year?
No, I mean the first is 8 months, and in the
No,
fourth-
no. Practically, how long is he in jail
Yes,
now
yes, my
till
lord.
today?
1 year, 4 months, 21 days.
21 days.
4 months, 21 days. Okay. And 506 days, my lord.
So, Miss Vanishami, he will get the remission benefit.
Yes.
I don't know how the jail calculates. Per month, some days are given.
Yes, Your Lordship.
So, I think he has another, how many months? August, September, October. 3 months.
3 months.
3 months. He might get remission for those 3 months and he should have been out by now. Okay, we will tell the jail authorities to calculate his remission period and give benefit. And whatever he has undergone sentence, that can be done. But of course, you have to show me the merit of the case.
Also, Your Lordship, my only submission is that since there is no minimum imprisonment mentioned in the Act for under Section 21B, so now the accused is sentenced to undergo 8 months. So
So minimum is not provided. That means from 1 day to so and so.
yes, so we can minimize the conviction and
Period undergone.
yes. So if it comes to 6 months and the fine so and so will be the same. So in that case, he can be released on bail under conviction only. So that in that regard, he will remain convicted, but his sentence
Yes,
will
whatever
be
is undergone.
minimized. Yes. So we can do like that also.
But just show me the merit of the case little. Read that page 1 of this report of seizure and arrest.
Yes, my lord. Page 1, my lord. Report of seizure and arrest. I have the honor to report that on 27 February 2025 at 11:20 p.m. at Van Book near Vanapa Hall, I seized the below noted articles, and in connection with the seizure, I arrested Zaudin Puya, son of Lalfam Kima of Klang Sam Champai, and Zoram Chana, son of Lalunzira of Klang Sam Champai district, on being detained by witness mentioned in seizure and arrest.
So, Joram Chana is the petitioner, is the appellant.
Yes, ma'am.
Seized articles
Seized article,
are 14 grams.
grams of suspected heroin packed in transparent polythene, kept in off-white color soap case, marked as S1. Second, 1.672 grams of suspected
Okay.
heroin, kept in 4 tic-tac containers. Black color rucksack used for keeping S1. The seized one soap case was recovered from the black rucksack, and 4 tic-tac container containing heroin was recovered from the wearing trousers of the accused, Zoram Chana, which was taken out by himself and handed over to me. Intimation of arrest was given to their relatives. I also recorded the seizure and arrest proceedings on mobile phone, and the hash value of the record is. I therefore request you to kindly register a case against both the accused persons under the appropriate sections of law.
So that seized one soap case
Yes, my lord.
was recovered from the rucksack and 4 TikTok container containing heroin was from Joram Chana only.
the appellant trousers, yeah, madam.
So 14 grams of suspected heroin in a off-white colored soap box. So this number one
Yes.
was also recovered from the appellant. 1.672 grams, 4 TikTok containers also from the appellant.
Yes, madam.
Black colored rucksack also from appellant.
Yes.
So not from the co-accused. He was simply with accompanying.
The co-accused was simply accompanying him from Champhai to Aizawl, my lord.
Achha. So the charge on the next page.
Charge was framed and that you on dated 27/2/2025 at 11:20 p.m. possessed 14 grams of heroin kept in one off-white soap case and 1.67.
Achha, these are all vernacular. It is not translated.
Page number 2 is translated, my lord.
Where?
No, the accused guilty statement is not translated.
That statement is not translated.
Yes.
So what does it say?
It's similar with the above written one, my lord. That you on dated 27/2. That's the
So
previous
just
statement, my lord.
translate it for me, these sentences
Uh,
that he had carried.
The accused has stated that in
Heroin, how?
they have seized heroin, one soap case and 4 Tic Tac from my possession, and from my trouser 4 Tic Tac, and one soap is seized from my bag. And we proceeded from Champhai along with the co-accused. That time we were in drunken state, my lord. From when we left the sumo, the excise and YMA personnel detained us and arrested us.
So I was proceeding with my friend, whatever, with my companion.
Yes, my lord.
With my companion from Champhai to?
Aizawl, my lord.
From Champhai to
With-
Aizawl
Sumo Mexica, my lord.
in a
Sumo Mexica.
sumo vehicle.
Yes, my lord.
And
when they immediately arrived at Aizawl,
when they arrived at Aizawl,
They
when
sus-
we,
yes,
uh,
they suspect of possessing and immediately detained and arrested by YMA and excise, my lord.
they detained us and they recovered.
Yes, my lord.
Okay. Same is the,
Same is the accused number 2, my lord.
that is not before us. He is not before me.
Yes.
Right.
Yes.
And then statement under section 67.
Under 67, page number 4, and translation is in page number 5, my lord.
Joram Chana.
Yes.
My name and residence is Vera. I used heroin for the year. Yes, when I was
Do I
caught
need
with
to read
60
that?
grams, 7 months under so and so. I was released after being convicted. He was also previously convicted.
Yes.
My friend asked me for heroin. We agreed at a selling price of 1 so and then went to Myanmar buffet for Wednesday. Now it has become a habit. His habit. He
This
keeps
is the
acquiring, selling, goes to jail, comes out
This
again.
is the second
acquires-
time, yes. Yes,
Achha.
yes, arrested.
I then went to Myanmar block. I purchased 2 soaps of bags. I sent pictures of my heroin. Cancelled this order saying that quantity was and then decided to sell heroin. And a friend to help me sell it. I had been offered to give him. Mm-hmm. 67 means these are the statement before the police officer, right?
Yes, man. Excise.
Excise. We reached Aizawl at 1 a.m. So Zodin Pua is not required.
Yes.
Then where
Page
is
number
the...
9 is the conviction order, my lord.
Uh-huh, okay. Yes. Judicial custody.
Page 11, para number 8, the statement is similar with that CC, my lord. And 13 is the sentence order.
Then sentence hearing, as you have already shown. Okay. Okay, I can dictate your judgment, Miss Vinishami.
Yes, my lord.
Yes, heard Mr. Swins.
8, daw din sa
Yes. And just give me NDPS Act, Mr. Michael. NDPS Act is there. Thank you. Sir, this is a criminal appeal filed by the appellant from jail challenging the judgment. Where is that? Okay. Challenging the, this is page 9.
judgment and sentence order, my lord.
No, where is the conviction order? I've just read.
Conviction order is in
Page 9.
page 9, my lord.
Challenging the order of conviction
Dated
dated 19/5/2025, as well as the sentencing order
21/5.
dated
21/5. Page 13, my lord.
page dated where is the date?
21/5. Page
It's in
number
the last page.
13.
Dated 28th of May 21/5. Where did you get that date?
It's in the top, my lord.
Oh yes, 21/5/2025. Passed by the court of special, passed by the special court, NDPS 1985, Aizawl Judicial District, Aizawl, Mizoram. The appellant had challenged the said order dated 19/5/2025, by which the learned court had convicted the appellant along with the co-accused under section 21B of the NDPS Act Full stop. Petitioner, the appellant had also challenged the sentencing order as stated above, by which the appellant was sentenced to undergo rigorous imprisonment for a period of 8 months with a fine of rupees 2,50,000 and in default thereof to undergo further rigorous imprisonment for another period of 1 year. Full stop. Para. It is the case of the petitioner No, not in the case. Para. Facts. The petition, the Inspector of Excise and Narcotics Anti-Narcotic Squad Mizoram Aizol had submitted a report of seizure and arrest before the officer in charge of the Anti-Narcotic Squad Excise and Narcotics Mizoram Aizol, wherein it was stated that on 27/2/2025 at around 11:20 p.m. at Venbuk, VENBUK, near Vanapa Hall, seized the informant seized the articles and the articles such as, not such as VIZ, dot 14 grams of suspected heroin packed in a transparent polythene, kept in a soap box, comma, 1.672 grams of suspected heroin kept in 4 tic-tac containers, TIC, tic-tac containers, as well as a black-colored rucksack black-colored rucksack in which the soap case was kept. Full stop. It was further alleged that the soap case was recovered. It is also alleged that all the articles along with the black rucksack was recovered from the appellant, which the appellant had himself handed over to the informant. Full stop. Along with the said appellant, another co-accused was also arrested in connection with the said case. Full stop. On receipt of the said information, the police registered the case as X-N, capital N, 33 of 2025, dated 28/2/2025, under section 21B of the NDPS Act 1985, against the appellant as well as the co-accused. Para. On completion of the investigation, the excise department, right?
Yes, my lord.
Investigation was by the excise department.
Yes.
The excise department submitted charge sheet. Where is the charge sheet? submitted charge sheet or offense report.
Page 22, my lord.
22.
Yes.
Okay, submitted charge sheet
24/4/2025.
23. 23.
Page number 22, my lord.
22. Charge sheet in connection. When was the charge sheet submitted? 22/4. Submitted charge sheet on 22/4, right? 22/4/2025. In pursuance to the same, the matter went for charge framing to the special court, NDPS Act, Aizawl Judicial District, Aizawl. And during the same, the learned court framed charge against the appellant the learned court asked the appellant, read over and asked him whether he pleads guilty. One second. 228, right? The learned court, upon consideration of the record of the case and the documents submitted therewith, asked the appellant about the offence. I think they have not filed any application for discharge also, right?
Yes, my lord. It was written in the conviction order.
On consideration and what did I say? On consideration of the record of the case and documents submitted therewith. Okay, asked the appellant about the offence. Full stop. It is also seen that the appellant had not filed any application for discharge. And the judge, the learned court, framed the charge under section 21B of NDPS Act for violation of section 8, for violation of the provision enshrined under section 8C of the NDPS Act 1985. Full stop. After framing of the charge, the said charge was read over and the accused was asked as to whether he pleads guilty or not. And to the said question, the appellant had pleaded guilty by saying that he proceeded with his companion from Shamfai to Aizawl in a sumo vehicle. Then, when they were about to sail, or what did he say in this local language?
When they were about to stop in the destination, my lord.
Acha. And when they were about to stop at the destination for selling the said contrabands, the personnel from the excise department reached this
Initially, my lord, they were intercepted by the YMA,
by
NGO, that Young Mizo Association personnel,
okay, were intercepted.
and detained by.
How can they detain? The association cannot detain.
It's written in
They were made to stop. Were intercepted
Your Lordship,
by
during the charge consideration, the way he pleads, he did not mention that he was detained by the YMA, Young Mizo Association.
so what did he say?
He just said that one hong of heroin and 4 Tic Tac container was actually seized from my possession, and that the Tic Tac 4 container of Tic Tac heroin was kept by me in my trouser pants, and another 1 hong of heroin was kept by me in my bag. And while they were coming from Champhai to Aizawl, while they were in the sumo, and they were getting out from the sumo. And at the time when they were getting out from the sumo, they were detained and gave them and proceed to the excise office, and there they pleaded.
Oh, they were taken to the excise
Yes.
office.
Yes.
Acha, Mashui, I had dictated that he was asked initially. Just read the first sentence, the charge framing. Read it from little before. No, before that, the court. Okay, forget it, I'll correct it then. Okay, saying that, you cut that last sentence, huh? So, saying that he had pleaded guilty by saying that he and his companion was carrying contrabands and was proceeding from Champhai to Aizawl in a sumo vehicle. And when they got down from the vehicle at one stop, they were detained, and the articles were found in his possession, and that he and his companion was taken to the excise office, where they were arrested for possession of contrabands. Full stop. Para. Subsequently, oh no, this 67 statement was before. It was before the excise authority, right?
Yes. During trial.
During investigation.
No, yes. that is
During investigation. Acha, before this charge framing, I've said that on conclusion of investigation, right? They have filed charge sheet. After that, you write during investigation. During investigation of the said case, the appellant had made statement under section 67 of the NDPS Act, wherein he stated that he had heroin. Wherein he stated that he was earlier in the year 2019 was caught with contrabands, and that he was jailed for that offense for 7 months and got released in the month of November 22. Full stop. He further stated that thereafter, one of his friend, one of his friend from Aizawl asked him for some heroin, and he and his companion agreed to get it and sell the same. To the said friend. He thereafter stated that he went to Myanmar and purchased. He went to Myanmar on 26/2/2025 and purchased the contrabands and came to Aizawl to sell the same. And he invited the co-accused to help him in selling the said contrabands. He thereafter stated that he had kept one soap case containing heroin in his backpack and tic-tac containers in his pocket and went ahead to Aizawl for selling the same. And that in the process, he and his companion was caught and was arrested. Then you say about those, charge framing and all. Fair enough. You said charge framing was on which date? 19th of May. Same day, right? After framing of charge, as mentioned above, on the same day, the learned court heard the parties after the learned APP opened up the case under section 226 of the CRPC. What will be the corresponding section in BNSS? Whether this has come after BNSS has come into force? Yes. Just see what is the corresponding provision of 226. Then you can give me that BNSS. (226) is here. Under section, you write 249. 249 of the BNSS 2023. The learned APP submitted that the inspector, what inspector? Inspector of what? It's not written.
It's supposed to be excise, my lord.
Inspector of the Excise Department.
Yes.
Inspector of the Excise Department received specific information about an association detaining 2 male persons for suspected possession. For possession of suspected contrabands. And on reducing it into writing, the said inspector went to the place of occurrence with her party and recovered the contrabands from the accused persons, including the appellant. It was, she further submitted. Oh no, the APP further submitted, he, she, I don't know. The APP further submitted that the accused persons were questioned and asked about the contrabands, and at which the appellant took out one soap case from his bag and 4 numbers of tic-tac containers from his trouser, and the same were seized. And on weighing it was found that the soap case, on weighing, it was found that the contrabands packed in the soap case was of 14 grams and the contrabands kept in the tic-tac containers were of 1.672 grams. Full stop. The learned APP further submitted that upon submission of that the inspector, upon submission of the report of seizure and arrest, registered the case against the appellant and the co-accused. She then submitted that the contrabands were deposited in the designated godown and the necessary entries were made in the godown register. Further, the statement of the accused persons were also recorded. She also submitted that the inventory was certified as correct. And no, the inventory which was prepared was certified as correct, which was prepared was certified as correct by the JMFC on 28/2/2025, and the samples were drawn, photographs were taken, and the samples were forwarded to the FSL for examination. The learned APP further submitted before the court that there was no violation of any mandatory provision of law and that 6 witnesses were examined by the investigating authority and also documents were exhibited. The APP as such prayed for framing of charge against the accused person. Full stop. As has been stated above, As has been stated above, no application was filed for discharging the accused persons before the learned court. The court, having found no procedural lapse during the search and seizure, framed the charge as stated above. The court had also examined the inventory prepared and being certified and all other procedures undertaken and found that the plea of guilt by the accused person was in corroboration with the available evidence on record. Full stop. It was therefore found that the facts admitted and the ingredients constituting the offense charged against them being found clean, unambiguous, and unqualified, proceeded to act under Section 252 of the BNSS 2023. Full stop. The court, being satisfied with the pleadings, the evidence is collected, and the guilty pleaded by the and the guilt pleaded by the appellant and the accused and the co-accused convicted the appellant and the co-accused under section 21B of the NDPS Act. Full stop. Thereafter, Thereafter, on 21/5/2025, the learned court heard on the sentence to be awarded to the appellant and the co-accused, and on conclusion of the hearing, imposed the punishment of RI for a period of 8 months with fine of rupees 2,50,000, and in default of the fine, RI for another period of 1 year upon the appellant, as stated above. Full stop, para. The learned counsel for the appellant submits that the appellant was sentenced as stated above. Appellant was convicted and sentenced as stated above on the plea of guilt at the stage of charge framing itself. He further states that appellant was arrested on 19/5/2025, and since the day of arrest,
27/2, my lord.
oh, he is arrested on 27/2/2025, and since the day of arrest, he is inside the jail. Both during the period of investigation and after the conviction is, oh no, not required, he is inside the jail, full stop. He submits that till today, the appellant has completed 1 year, 4 months, and 28 days of incarceration. And to complete his sentence, including the sentence for non-payment of fine, only 3 months, few days are left. He submits that the appellant be treated with leniency and be released on the period undergone. Para. On the other hand, Ms. Veneshami, learned APP or PP? APP for the state of Mizoram submits that the learned court, after going through the entire records of the case and the documents submitted therewith, and after hearing the learned public prosecutor for the state frame the charge against the appellant and read over the same to the appellant and the said charge was also explained to the appellant. And when the appellant was asked whether he pleads guilty or not, the appellant answered in the affirmative that he pleads guilty. That he pleads guilty. Full stop. She further submits that the learned court, upon consideration of the materials on record and on finding that all the procedures were properly followed, together with the plea of guilt of the appellant, convicted the appellant rightly under section 21B of the NDPS Act. Full stop. Para. Hey, Michael, he always brings the pad, and now when I needed that, it's not here. Just tell him to give me the iPad. Okay, then you had given facts, right? And then make it submissions. Before I said that he submits submissions. And now say analysis and findings. Although section 226, what is the corresponding section in BNSS, I said? Thank you. 449, yes. Although under section 249, wait, 49 or what? I'll just see it. Under section 251. Although under section 251, it is provided of the BNSS 2023, it is provided that upon consideration and hearing, upon consideration of the record of the case and the documents submitted along with the same, and after hearing submissions of the accused and the prosecution on that behalf, if the judge is of the opinion that there is ground for presuming that the accused had committed offense, will frame the charge under clause B of the said section in writing. And not required under clause B, you write, frame the charge in writing against the accused person. Full stop. It is further stated, it is further provided that when the judge frames this said charge, the same shall be read over and explained to the accused person, and the accused person shall be asked whether he pleads guilty of the offense charged or claims to be tried. And if the accused pleads guilty, wait, 251, right? Achha, 251 I started with although, right? Don't give although there. Forget about although. Under section 251, of the BNSS, it is provided, right? Then you put a full stop here. It is further provided under section 252 of the BNSS 2023 that if the accused pleads guilty, the judge shall record the plea and may in his discretion convict him thereon. Now you say, full stop. Although it is provided for under the said provisions that the court can, in its discretion, convict the person who pleads guilty, but it has been held by the Honorable Supreme Court that even in such cases, for the ends of justice, the court should conduct a trial, a complete trial, and impose punishment and convict the accused person and impose punishment. Full stop. However, the same has not been done in the instant case, and the court and the learned court had convicted the appellant on his plea of guilt, along with the records, along with the consideration of the records of the case. Full stop. In the instant case, it is found that the appellant, on being apprehended, had himself taken out the contrabands both from his backpack and from his pocket and handed over to the authorities concerned. Upon measurement, no, not measurement, upon weighing the contrabands, the same were found of intermediate quantity. It was also seen that the appellant had not filed any application for discharge before the learned court during the charge framing stage. the appellant are seen to have completed the maximum part of the sentence. No. The seems to have complete the substantive sentence imposed upon him for violation, imposed upon him for the offence under section 21B of the NDPS Act. That is the period of 8 months. But he is still inside the jail for completing his additional, for completing the additional term of 1 year because of the fact that he could not pay the fine. Of 25 lakhs.
2.5 lakhs, madam.
Huh?
2.5 lakhs.
Oh, chal. 2,50,000, right? 2,50,000. In view of the facts of the present case, in view of the facts and circumstances of the present case, this court finds it fit that the petitioner be released on the ground of period undergone. But he will again come out and again do the same things, right? It cannot be done also. Undergone. This court, it is also not, this court will also not lose sight of the fact that by giving the benefit of remission, the period of remission, giving the benefit of period of remission, the appellant must have finished the sentence period by now. The appellant to be released forthwith, if not required in connection with some other case, send back the LCR, appeal is disposed of.
Madam,
something?
my my fee
Oh,
may
yes,
be-
yes.
may-
Mr.
as per the
So-and-so.
existing legal rules.
That line you give, we appreciate the service rendered by learned so-and-so, learned amicus curiae. As such, it is directed that he be paid the necessary remuneration by the
Legal service rules.
legal services authority.
Yes.
Legal services authority, ISOL.
Yeah. Yes.
Legal services authority, ISOL.
Yes.
Within
That's
within a reasonable period of time. Otherwise, they take long, I'm told sometimes.
Deeply obliged.
TCR to be send back the records. Okay. Yes.
Item number,
Yes, Mr. Lalpakama. What is so urgent?
My lord.
You
At the
can
outset-
you can also move the application in on Monday morning.
That is the thing, Your Lordship. It might be too late on Monday morning. At the outset, Your Lordship, I'd like to extend my gratitude
And you
for
have come in the 11th hour.
my lord. What to do, my lord?
Okay.
Such is the
What is
nature
this
of this
Gallant
business.
Sports and Infra Limited having?
Yes, Your
problems?
Lordship.
Okay.
I am a private limited company based out of Gurgaon. Today, I'm being represented by my authorized local representative. I am, amongst others, I am in the business of selling, construction, and laying of artificial football turf.
Now, football turfs.
Football turfs.
Acha, the grass, I mean.
The grass, the artificial grass.
Okay, in the stadiums.
In the stadiums, yes. So I have completed various projects in and around Northeast and other parts of India, especially Goa and Kerala, so on and so forth. So I have enough experience. And not only that, Your Lordship, I am also a duly certified empaneled consultancy firm grade A in the state of Mizoram. My certificate of empanelment can be found at page 21. Annexure 3.
21.
Yes, Your Lordship.
Okay.
This is a certificate of empanelment dated 29 May 2020.
Certificate of empanelment. Okay.
Yes, Your Lordship. So out here, what is important, I would like to emphasize on is the fact that I am a consultancy firm grade A.
Empaneled as consultancy firm grade A.
Yes, and my consultancy is for a period of 3 years.
This is Gurgaon, having its registered office at Gurgaon.
Registered office is in Gurgaon, but we have our local partners. So we have completed various works, including one in Mizoram as well. Now, the present respondent number 2, and also at this point, what I'd like to mention is that I am the exclusive supplier of artificial grass supplied by Co-Creation Grass. They are a Vietnam-based company, and they are one of the very, very few companies that is FIFA approved, or they call it FIFA preferred artificial grasses.
Acha, acha. So FIFA approved.
Preferred, as they call
Preferred.
it. I mean, that's the
Acha, acha.
business language, I guess. In any event, Your Lordship,
So you procure materials from Vietnam party.
yes, and I'm the exclusive distributor.
You exclusive distributor
India.
of artificial grass.
No, of that company, that FIFA preferred artificial grass. There are different qualities of grasses, but the one I'm supplying is a FIFA preferred, basically certification from FIFA.
FIFA preferred artificial grass.
Yes.
And you get it from Vietnam.
Yes, and I'm the exclusive distributor
You are the exclusive distributor.
in India.
Okay. The Gurgaon company you mean?
Yes,
and
the
then
Gurgaon
you are
company.
the.
Yes. So that is the situation, Your Lordship. And if Your Lordship can kindly turn to page 32.
Okay.
This is a request for proposal issued by the respondent number 2. May I read, Your Lordship?
This is the bid.
This is the bid. This is the tender bid. The RFP is invited from interested eligible government empaneled firms grade A, which I am, registered companies, etc., for the undersigned project, which will be received by the undersigned at the stipulated time as shown below. This is for construction of artificial football turf at Joint Waimea Field 5 on Aizawl, which is just down the road, Your Lordship.
Sirship.
Yes. So the estimated cost is put at 9.51 crores and some change.
Wait, 1047, what?
9.51.
Estimated cost is so and so.
9 crores 51 lakhs 42,900 is the estimated tender cost. And at the second paragraph, Your Lordship, details may be seen
No,
from.
where? The estimated cost is 10.47, what? 10 crore 47 lakhs.
I am on WPC 97. I am on.
There are two matters.
Yes.
Yes, WPC 97. Page 32.
Yes. I think we've. Yes, Your Lordship. It's the same. It's just that the
Same.
location is different, estimated cost is different, otherwise the facts are all the same.
So, Shership District, Mizoram.
Yes, Sirship District, Mizoram. So, in the second paragraph, there we will have that details may be seen from the office of the undersigned during office hours on all working days and at so-and-so website and the said procurement portal www so-and-so with effect from so-and-so. The tender will be received in the office of the undersigned up to 12 noon on 27/2026, which is Monday. And the same will be opened on the same day at 1 p.m. on
This
Monday.
was floated when?
At the next page, Your Lordship. This is 29th of June 2026.
So, you had many days.
Yes, Your
What
Lordship.
happened? You have come.
I had submitted my representation to the government and I was waiting their response, Your Lordship.
So, what is your prayer now? What happened?
My humble prayer is that, Your Lordship, we are aggrieved with one particular clause, only one clause, in fact, Your Lordship,
In this bid document?
in this bid document.
Where? What?
Clause 4.4. I will come. Page 48. Page 40. Your Lordship has that qualifying criteria. 4.4. And below there is a checklist table.
Wait. 48.
48.
49 actually.
49 actually, it starts from 48 and relevant page is at 49. There at 4.4 we have qualifying criteria. And then at the bottom we have this format of checklist, that box is there. In the next page, Your Lordship, here at the second column, the second box I say, the bidder shall be qualified only if she fulfills the following technical bid. It says we are basically aggrieved with this particular condition.
Actually.
The bidding firm must have successfully executed at least 6 FIFA standard artificial football turf grounds in Mizoram.
In Mizoram.
Now that is what,
FIFA standard artificial turf football grounds in Mizoram.
yes. So as
It's
per
not possible for Mizoram to have 6 standards artificial turf football,
although
right?
it is technically possible,
But till
but
today,
then-
till 2026.
but this means that if this particular condition is included, the entire bidding process will be only limited to 1 or 2 firms, eliminating all other.
That is not unreasonable. I think there are judgments saying that
We have
even
that, we
if
have
it
that.
is confined to few competitors,
In fact, we have one judgment, a 2025 October judgment, which basically is very, very similar in facts and circumstances to this particular case. In that case, there was this issue of the government had floated a tender for supply of sports kits to schools. In one of the condition was that the bidder must have supplied sports goods for at least 3 years in Chhattisgarh. So that was done away with by the apex court. So
depends on facts to facts.
yeah, but the facts are quite similar. That's what I'm trying to say.
So you are
So-
challenging only this.
Only
6.
this.
You
And-
should have executed 6 FIFA standard artificial
Correct.
turf.
So by
In Mizoram.
by limiting the experience needed to only 6 in Mizoram state alone, that will eliminate a lot of other eligible candidate, Your Lordship, who can provide a much higher and a much better quality at a lower
But then
rate.
that is the prerogative of the department.
In fact, Your Lordship, how this particular clause is contradictory, I would like to take Your Lordship to the next page. Next page out here, it says product quality.
Where?
And in the next page,
Yes,
page
product
51,
quality.
product quality. So I don't exactly understand the industry standard, but in any event, the requirements and composition, so and so, everything is given. If the product quality is going to be the same, then why limit the bidding process only to those with 6 experience in Mizoram? What would be the purpose behind that? What would be the idea behind that?
Because to see your competency, to see your that you have done 6 numbers of work.
I have done all over India. I have done in Notice also, my lord. I have submitted my
But in
certificate.
Mizoram, you need 6.
Correct. So
executed work.
that we feel is discriminatory and that it is tailor-made into favor of few bidders. In that regard, Your Lordship, that is number 1. First point of my challenge. The second point, I would like to take Your Lordship to the previous page at page 47.
So your first point is condition
4.4, serial number 6. Serial number 4, sorry.
4.4,
Clause 4.4.
yes, serial number
4.
4. Serial number 4. Okay, then the next.
Next is previous page 47. At clause number 3.3H.
H, yes. The lowest bid will be acceptable.
Is only 5% below the tender cost of work. This is in violation of this Honorable Court's direction, Your Lordship. And there's one more point similar to this at page 54.
Yes, wait 1 second. H. Okay. The lowest bid that will be acceptable is only 5% below the tender cost of work. Okay.
And another similar clause is at page 54, clause 4.19.
54. Clause
4.19, the last one.
54, 4.19.
Yes, my lord.
Yes.
As per the Finance Department, Government of Mizoram notification, vide number so-and-so dated 5th July 2024, The permissible lower limit while considering tenders has been fixed at 5% of the estimated cost, and the permissible upper ceiling is fixed at 10% of the estimated cost. Now, this particular notification has already been superseded.
Acha.
I have annexed that particular notification. Your Lordship may kindly turn to page 109, Annexure 6.
So this notification was
Superseded.
superseded.
And the new notification has also been stayed by the division bench on of this honorable court.
State.
The new notification.
New notification also state.
Also state. Page 109, Your Lordship has it.
109, yes.
This
Version
is
of decision meeting
notification
is
dated 5th July 2024. So this is the same notification which has been spoken about at page 54, 4.19. And in the next page, Your Lordship, at page 110, it says, in supersession of the notification of even number dated 5/7/2024. So clause 4.19 itself is incorrect in fact.
This is on 15th of July. When was the very floated?
29th of June 2025.
So before this amendment, before this notification.
After, my lord, after.
Oh, this
This
is
is
15 July
2024.
24. Acha.
Tender was in 26th of June, June 26. So as Your Lordship can see from page 110, that notification has already been superseded.
Now superseded, and what is the new condition given?
There is no condition now
The
because
permissible lower
this
limit
5th July 2024 was put to challenge by way of PIL before this honorable court, which is at page 109.
109. Okay. 109? No.
Sorry, I apologize. 1010, 1011, 111, 112 is the.
Okay.
So PIL 1 of 2026 is there. So this is a division bench. In this paragraph number 2 itself, Your Lordship, the learned counsel for the petitioner submits that a public spirited person has filed the instant PIL to espouse the arbitrariness and illegality committed by the state respondents in coming up with the notification dated 15/7/2024, fixing the permissible lower limit of tender at 5% below the estimated cost and the higher ceiling at 10% above the estimated cost. Now, if I can take Your Lordship to the 11th page, at page 116, towards the end. It says,
In the interim.
in the interim, we are of the view that the impugn notification dated 15/7/2024 as well as the so-and-so as it was, should be stayed.
For procurement of building and other related works as well as road work should be stayed. There is a rider there. Right.
It is stayed, my lord.
No, I mean, accordingly, we are of the view that interim order, it's not blanket stay. This is as well as SBDs for procurement of building and
So
other
there are two
related
things that
works.
have been stated. One is the notification dated 15/7/2024. In any event, we are not so concerned with this 15 notification because as per the clause 4.19, the basis of the of coming to inserting that clause was the notification dated 5th of July.
Okay, which is no longer
Superseded.
exists. Which no longer exists.
Correctly, my lord.
Then this is the third point.
So my prayer is limited to challenging these two issues. One is the insistence on bidders having completed at least six standard artificial turf football grounds in Mizoram. And the second one is the lower permissible limit of 5% and higher permissible limit of 10% as they are ultra vires.
Okay.
So in both the cases, the
And your second point was 3.3H.
3.3H and 4.19 are the same.
Which, what was that page number? 3.3H?
3.3H is at page 47.
47. Okay.
4.19 is at page 54.
Yes, that I have. Okay.
So my limited prayer is only on these two aspects. Now, just to buttress my submission, I have provided Your Lordship with one citation only, just for Your Lordship's consideration.
That Chhattisgarh.
The Chhattisgarh one. This is a 2025 SEC Online SC 2119. This was the delivered decision was taken on October 6 of 2025. So it's a relatively new judgment. The relevant paragraph would be at para 17 onwards. Your Lordship has para 17.
Yes.
May I read? In the backdrop of well-settled legal principles, we advert to the fact of the case in hand. The present tender is for supply of sports kits to the students of primary school, upper primary and higher secondary school run by the state government in the state of Chhattisgarh. The eligibility criteria mentioned in the impugned tender notice must have rational nexus with the object sought to be achieved. That is, supply of good quality sports kits to students of the school at the best price. The eligibility criteria in the impugned notice therefore should be framed in a manner which encourages wider participation and secures the best price for the state, which in turn safeguards the public exchequer. The court in Bharat Force Sopra has enunciated the doctrine of level playing field and has stated that the same finds expression in Article 19(1)(g) of the Constitution. The doctrine of level playing field requires that all equally placed competitors must be given an equal
So
opportunity
this
to.
doctrine level playing field.
It should be doctrine of level playing field.
This doctrine of level playing field, it's a new term that I'm hearing. The doctrine of level playing field means you have to have more competitors and you should get the best
It should
price.
not be restrictive. And even if it's restrictive, it should have a close nexus with the object sought to be achieved as provided under Article 14. So in the present case, the object sought to be achieved is what? Number one, the best possible product at the best possible price. That should have been the object of that state.
Then the doctrine of level playing
The doctrine of level playing field requires that all equally placed competitors must be given an equal opportunity to participate in trade and commerce. It is designed to prevent the state from skewing the market in favor of few by erecting artificial barriers. In the instant case, the impugned tender condition has the effect of excluding bidders who, though otherwise financially sound and technically competent, have no experience of supply of sports goods to the state government agencies of Chhattisgarh in the past 3 years. The state, by linking the eligibility criteria with past local supplies, has created an artificial barrier against the suppliers who had no past dealing with the state of Chhattisgarh. The impugned condition curtails the fundamental rights of the bidders who have been ineligible to participate in the tender. The object of public procurement is.
This should be enough, right? There are more paragraphs you want to place.
Basically, this para 19 and 20 only. I'll just quickly read my note.
Okay.
The object of public procurement is to secure quality goods and services for the benefit of public exchequer. The said object can be achieved by requiring the bidders to demonstrate financial capacity, technical experience, and past performance in contracts of similar nature, regardless of place of performance of the contract. To confine the eligibility to participate in tender within one state is not only irrational, but is also disproportionate to the goal of ensuring effective delivery of sports kits. The last paragraph only, brother. Such a restriction, therefore, cannot be justified as reasonable within the meaning of Article 19(6) of the Constitution of India. The state, while it enjoys the freedom to prescribe the conditions in tender, cannot exercise that power in a manner that infringes upon the constitutional guarantees by closing the market to outsiders without just cause. The doctrine of level playing field requires that gates of the competition be open to all who are equally placed. The impugned tender condition excludes the competition and experienced suppliers who may have executed contracts of far greater magnitude in other states or for the central government departments from participating in the tender and has the impact of promoting cartelization. The impugned condition operates as a closed door to outsiders and restricts the wider participation of bidders and restricts competition. The impugned tender condition, therefore, is violative of Article 14 and also offends Article 19(1)(g) of the Constitution of India. So, in my humble opinion and as per my humble interpretation, my lord, this particular judgment would squarely cover the present case.
Yes.
The second writ petition, my lord, everything is the same. It's just that the location and the tender amount is different. Otherwise, it's the same conditions.
Only the location is different,
Only
not Charship, somewhere else.
It's in that one is in Aizawl, and the tender value is slightly different. That's all.
Okay. What does you are appearing for the
Just lastly, so as I had read out at page 32, my lord, the bidding process is due to be opened on Monday at 1 p.m. So my humble prayer is that an interim stay may be granted till the next returnable date at least. We can, I believe that a short date will also suffice.
Okay, let me hear, then I'll decide on the interim. Yes.
Your Lordship, regarding the merit of the case, since I have received the copy of the writ petition yesterday only, last night, so I need to take an instruction regarding merit of the case. And regarding the stay, my proposal, so to say, is that instead of giving an interim stay for the tender process, bidding process,
It will be kept in seal cover.
or will it be appropriate instead of giving stay to the tender process, Your Lordship, let the petitioner participate, but without disqualifying him by this 3.3H as well as 4.4 of the request for proposal,
But how? He
And
is not
subject to-
qualifying.
and subject to the outcome of the writ petition, then it could be finalized, my lord. Will it be more approved? Because staying of the bidding process, it will affect the public interest as well, because the work will be delayed. Suppose if it is stayed, and maybe after the, although it could be subject to the outcome of this writ petition, a fresh tender process will be floated again. Instead of doing that, let him participate, but without disqualifying him by this 3.3H as well as 4.4, but subject to the other non-fulfillment of the criteria. That is, we can't say. Only because he is challenging this 3.3H and 4.4 of the request for proposal only.
That sounds reasonable. You participate without being affected by this
And the
disqualifying conditions.
subject to the outcome of writ, then
Let the bidding continue, my lord. Then the results, as your lordship suggested, let it be in a sealed cover till the disposal of this case.
But then you'll have to be given permission to participate in that bid proceedings. Otherwise, you are disqualified because of these.
My lord.
So that direction has to be given.
to maintain fairness, let the petitioner be protected by this honorable court by this in respect of 3.3H as well as 4.4.
As far as the notification, that seems to be okay. His submission seems to be okay. That is superseded by the recent one, by the later one. And so they could not have emphasized on that notification anymore after such long period. And that new one is also stayed. So as far as 4.4, his experience for 6 number of works
In Mizoram.
in Mizoram. And the other one is your
That one, is that regarding
H is what? 3.3H was what?
3.3H is regarding the minimum criteria,
Yes, 5%,
5% of the tender
the estimated
amount.
cost. So that, let the two, let him participate in a
Yes.
bidding process without taking into account these two clauses.
Yes.
And his success will depend on the outcome of the case.
Yes.
My lord.
That will be all right, I think. Instead of staying the whole process, my lord.
But that will what happen? He will only get the relief. There will be.
What about the others?
What about the others? If there are more competitors, in
Again,
the
there
fray-
would not be a level playing field for the others.
But the other, suppose if your lordship, if in the financial bid, suppose he goes through the technical bid, and in the financial bid, if he is not the lowest bidder, then the other bidders will be successful bidder. So it will be fair enough.
And he is only before me. Why should I think about the others?
Yes.
And this constricting the competition is also allowed. This is also in facts of the circumstances. Supreme Court has said that this is permissible. If by giving condition you restrict the competitors, you restrict the participants, not always violative of Article 14. There are judgments. Of course, we have shown this Chhattisgarh judgment where it is said that as much as participation should be encouraged. But there are judgments where it is said this is in the prerogative of the department to restrict the competitors
In fact,
by
my lord,
laying down conditions.
as per my humble understanding, is that restrictions definitely can be imposed by the government, but that is subject to the judicial review under Article 14,
No, that is
19(1)(g).
always subject to, if any reasonable classification is not made.
Our basic case is that why restrict it to 6 works done in Mizoram? You're saying that on one hand, you're saying that you must have experience of at least 6 in Mizoram. At the same time, you're also providing the specifications for the quality of the products to be supplied. So it has no bearing on the quality or the cost or anything. Because in any event, regardless of whether it's in a hilly state or whether it's in a plain state, laying of artificial football turf requires a plain area. It has to be level.
Okay.
Anyway, regarding the merit of the writ petition, will be filing an affidavit, my lord. We'll counter the writ
that you-
petition as well. Yes.
Yes. You give him copies and then you have got copies?
Yes, I've already got
I will
copies.
furnish extra copies also if
Okay.
necessary.
Heard Mr. Lal Fakama, learned counsel for the petitioner, and Mr.
B. Laramanga.
Laramega
For respondent number 2, my lord.
and secretary is Secretary Veneshami, you are appearing? Yes, and Miss Veneshami for respondent number 1.
However, Your Lordship, the copy has not been furnished.
Okay, extra copies will give it to you. This is a petition filed under Article 226 of the Constitution of India, praying for a writ of certiorari for setting aside or modification, for setting aside or modification of the clause 4.4, serial number 4, under the head format of checklist in the request for proposal dated 29th of June 2026. Full stop. In the said clause, it is provided that for construction of, oh, no, full stop, you say that it is the case of the petitioner that request for proposal, the NIT, you don't say NIT nowadays, right?
Yes, they've used the nomenclature request for proposal.
RFP,
RFP.
okay, request for proposal, RFP, number PR-432/MSSC/2026, dated 29th, no, so 26, was floated. Where is the NIT? Where is this?
Page 32.
Was floated.
The next page.
Floated for construction of artificial football turf at JT dot YMA field. But this is not JT, this is Sirship somewhere.
Yes, Your Lordship, at
Page?
page 32, annexure 5.
Yes.
I apologize, there's some.
No, this
correct
is,
it.
I saw somewhere the football stadium of Sirship,
Page 32.
and here you are talking of
I-
Vivacon.
we have inadvertently mixed that. We will correct it, Your Lordship.
Acha, acha. So where is, this is in relation
This
to
is-
Sirship, right?
The present one is in relation to Sirship,
Okay.
but that particular page relates to the second writ petition.
Acha. For construction of artificial football turf at East Lungdar, LUNGDAR, comma, Sirship, SERCHHIP, District, Mizoram. The learned counsel for the The learned counsel for the petitioner submits that he is aggrieved by the condition prescribed in the said request for proposal embodied at 4.4, serial number 4 of the same. He submits, where is that? 4.4,
Page 50.
page 50, yes. He submits that under the said condition, it is provided that the bidding firm must have successfully executed at least 6 FIFA-standard artificial turf football grounds in Mizoram. But there's a rider, you see, in exceptional cases, firms with minimum 4 completed projects can also participate.
Correct, my lord.
How many experience do you have?
In Mizoram, one.
One only.
But I have completed works in Tripura,
states.
Manipur, Arunachal, Goa also.
Okay. The Learned Counsel submits that the petitioner has successfully executed FIFA standard artificial turf football grounds in various parts of the country and one in Mizoram. However, he submits that the said condition that the 6 numbers of works should have been executed by the bidding firm is unreasonable. In the facts, bidding in Mizoram is unreasonable. And the same restricts the participation of the companies related to such work. The Learned Counsel also submits that the petitioner is also aggrieved by the condition enshrined under clause 3.3 H, subclause H of the said request for proposal, wherein it is provided that the lowest bid that will be acceptable is only 5% below the tender cost of work. What do you say on this? What is the ground?
This has to be read together with 4.19 at page 54. Because the same is based on a notification which no longer exists.
Achha. The Learned Counsel submits that at clause 4.19 of the bid document, it is provided that the notification dated 5th of July 2024 prescribing, issued by the Government of Mizoram Finance Department, prescribing the permissible lower limit is superseded, was superseded by a subsequent notification dated 15th of July 2024, and that the subsequent notification has also been stayed by the division bench of this court. Full stop. He submits that the condition prescribed at subclause H of clause 3.3 of the bid document was based on the said notification, which was superseded by a subsequent notification, which is again stayed as stated above. He submits that the petitioner as such is aggrieved by the said conditions. To substantiate his argument, he has placed reliance on a judgment of the Supreme Court passed in Vinishma, Vinishma Technologies Private Limited versus State of Chhattisgarh and another, reported in 2025 SCC Online SC 2119, by which the Apex Court had observed that the basic feature of a tender being to get the best possible quality products or work and at the best price. The participation best price, the notices inviting tender should encourage wider participation of the bidders. In the instant case, the learned counsel submits that by prescribing the aforesaid conditions, the participation is constricted. Full stop. He also submits that the quality, where was it? The quality of the, oh yes, page 51.
Yes.
He further submits the quality prescribed for laying down the artificial turf in the football fields in the bid document is fulfilled by the petitioner concerned, but only because of the condition that he should have executed at least 6 numbers of work in Mizoram, restricted his participation in the said bid process. Issue notice, issue notice, returnable by 3 weeks. Mr. So-and-so appears for respondent number 2, and as such, no formal notice is required to be served upon him. Ms. Venishami, learned State Counsel, appears for respondent number 1. However, extra copies to be furnished to the respondents by the petitioner within a period of 3 days from today.
My Lord, sorry to intervene. In my name, Your Lordship, standing counsel for respondent number 2. It may kindly be added. I'm the standing counsel.
Oh, you're the standing
yes,
counsel?
for respondent
Achha,
two.
standing counsel for respondent number 2 appears, huh? In the interim, in the facts and circumstances of the case, this court, in the interim, finds it fit that the petitioner be allowed to participate in the bid process, which is scheduled to start, which is scheduled to be open.
Closed on 20th of July.
Where is that? You had shown me?
Page 32.
32.
The second paragraph. Last line.
Acha, huh. Will be received, okay. Which is scheduled to be, what do you say, which papers has to be submitted before this date, right?
Bidding process will close at 12
Acha.
noon.
Which is scheduled to be closed on 27/2026 at 12 noon. Without taking into account the conditions, without pressing on
Unless,
satisfaction.
may I make one small submission? If what I understand that my learned friend is trying to figure out the best way possible for all parties involved. But if I'm allowed to participate without taking into consideration this clause 4.
Yes,
serial
this
number
is
4,
what I'm saying. Without
Then
pressing for
this-
satisfaction of this clause.
then this entire petition will become infructuous.
No, only to participate, and it will be kept in seal cover,
Mild.
right?
Yes.
Till the next date, or till the disposal.
Till next date, my lord. I
Till
think
next date.
tender we anyways move quickly.
Yes. Okay. Without pressing on the satisfaction of the condition prescribed under serial number 4 of clause 4.4 of the bid document, as well as subclause H of clause 3.3 of the bid document on the part of the petitioner.
Clause
And
4.19.
the said papers should be kept in seal cover till the next returnable date, or what? Should
May I
be
make-
kept in seal cover.
May,
Full
may I
stop.
make one small suggestion, just for the sake of clarification? We all understand what your lordship is trying to imply, but then a wrong interpretation might be given. So, sealed cover of all the bits. It should not be open till the next returnable date.
For all the bits, of course, that has to be kept.
Yes, should not be open till the next returnable date.
Okay.
This should be financial bit.
The bid documents of all the parties should be kept in seal cover. ऐसे लिख देना last week. And the bid documents of all the parties should be kept in a seal cover.
My lord, I think we can.
And the same may not be opened till the next returnable date. That is okay.
My lord, I'm satisfied. My lord, friend.
Yes,
That
I
will
think
be-
that will be okay, my lord. That will be
Okay. All will be kept in seal cover and it will be opened.
Yes.
It will not be opened till the next returnable date. Then you take an order again. Because this is technical bid, right?
My lord, once you qualify for technical, only then the question of finance will come.
Financial bid comes.
Whether it would be required to mention that the finalization will be subject to the outcome of, or whether it is premature.
It is only till next
Yes.
returnable date.
Yes, thereafter only.
Thereafter, it will be decided
yes.
again.
My lord.
Okay, till the next return. List this matter on 25th of August or what? No. You
It will
suggest
be-
on a date?
Yes. If it can come closer, my lord. It will be
Let it be listed on 19th of August.
23rd. My lord, 23rd of July,
Next week.
next week.
23rd. Oh, yes, yes. 23rd of July. This 23rd.
Yes.
No, not 28th of July. 27th.
27, yes, my lord.
27th or Monday. Okay. List this matter on 27th.
Your
Any
Lordship,
clarification?
Yes, Your Lordship. In that, Your Lordship had mentioned clause number so and so, so and so. After 3.3H, my Lord, I believe Your Lordship has missed out on clause 4.19. 4.19 talks about that notification.
Yes.
I believe during Your Lordship's
In
dictation.
that case, 3.3H is not required if 4.19 is not pressed for. No, these are all independent, right?
They're interlinked.
Yes, 3.3H दिया ना और लिख दो वहीं पे as well as 4.19 of the bid document yes.
Deeply obliged.
Okay.
That's
Any changes I'll make it.
My Lord. The second writ petition, my Lord, everything is the same. It's just that the location is different and the estimated cost is different. That's all. Otherwise,
Estimated cost I have not put.
so only the location.
Okay,
and
look, it is not sureship, it is
Joint YMA field, Vivacon.
This is Vivacon Isol, artificial football turf at JT.YMA field, Vivacon Isol. Only that difference.
Only that difference.
Sureship and Vivacon. Okay.
Deeply obliged.
Any more matters since second up? I'll come at 2 p.m. or what? You give me the information. If they are there, then let me know. Okay.